I'm going to tell you about some facts that you may not know about VAWA and why this immigration relief may be for you. I'm immigration attorney Sharifa Tharb, and this is exactly what we do. We help clients to get their green card in the United States without the need to leave. Here are facts about VAWA and why you should apply for it. VAWA is a kind of immigration relief for certain immigrants whose relatives are mistreating them, abusing them, or subjecting them to extreme cruelty. These relatives could be a U.S. citizen or resident spouse. It could be a U.S. citizen or resident parent, or it could be a U.S. citizen son or daughter who's age 21 or older. The main criteria for VAWA is that you have to show that you were subjected to mistreatment or extreme cruelty by this U.S. citizen or resident relative. There are other criteria that you also have to keep in mind. You also have to show that you resided in or you currently reside in the United States with this relative. The other criteria, in addition to showing mistreatment or extreme cruelty, is you have to show that you at some point resided with this relative. You have to show good moral character. You have to show that a qualifying relationship exists. That means that you have to show the parent, son or daughter relationship, or you have to show that you were in a bona fide marriage. That means that the marriage was real. So now that I've broken down what qualifies you for VAWA, let's talk about the facts that are not often talked about but could make a difference for you. VAWA is a type of relief that's available to immigrants who enter the country without permission. Some like to say enter the country illegally, or who ended up overstaying their visas. There is a misconception among some immigrants that this relief is only available to immigrants who currently have their immigration status and not to those who may have entered without inspection or who may have overstayed their visa. So keep in mind that you can apply for VAWA. This is to be able to get your green card, your work permit, your travel document, protection from deportation, even if you don't have your papers, even if you entered without inspection, even if you overstayed your visa. You have to be divorced if you're going to apply for VAWA. Not true. You do not have to be separated or divorced to apply for VAWA. You could currently be still residing with your spouse but looking for relief to be able to gain the type of independence you need to leave the situation. And even in the case of divorce, you will have up to 2 years after the divorce is finalized to apply for VAWA. You have to face physical violence. A police report has to be filed in order to qualify for VAWA. Unfortunately, even other attorneys have this misconception, and because of that, many individuals are misinformed about whether or not they qualify. It is very much acceptable for one to show other ways in which they were mistreated: emotional abuse, financial abuse, verbal abuse, mental abuse, manipulation, isolation, degrading. That counts as mistreatment as well and does not require any kind of showing of physical violence or a police report. You have to provide evidence that's going to prove without a doubt that you faced this mistreatment or abuse. This is wrong. At the USCIS, they consider any credible evidence as evidence that can result in an approvable VAWA application. Once again, that means you get your green card, your work permit, your travel document as part of the process. Evidence can even include your detailed declaration, We know because we've done this for our clients. This relief under VAWA is not just for marital relationships. It also includes other types of familial relationships like the parent-child relationship. A parent can apply for this immigration relief if their son or daughter aged 21 or older mistreated them. A child under 21 can apply for this relief if their parent, which could be a U.S. citizen or a resident parent, mistreated them. In addition to that, even if the child is now over 21, they can still apply for this relief as long as they have not gotten to the age of 25, and they can show that a delay in applying when they were under 21 was directly caused by the mistreatment by the U.S. citizen or resident parent. Your children can be included in your application. Many times, I do consultations with individuals who are going through the marriage-based process and they want to stick out the marriage-based process for the sake of their own children. And this is what I have to tell them. Their children will be included in the VAWA process if they want to move from the marriage-based process to the VAWA process. It protects the children as well as the parent. VAWA can be a way to overcome the permanent bar. Yes, I said that right. The permanent bar is usually caused if one is deported from the country and then returns without inspection, or if one is in the country, overstays over 180 days, and then leaves the country and then returns without inspection. So be very careful about that. Now, once you have a permanent bar, before you can even apply for permission to come back into the US, you have to be away for 10 years. However, in this case, under VAWA, it could be different if the mistreatment is the cause, the direct cause of you entering the United States after leaving. VAWA allows an individual to overcome the permanent bar if they can show that the abuse or mistreatment that they experience is related to their re-entry into the United States. If you have a criminal offense on your record, you can't qualify for VAWA. That's the misconception. Absolutely, you can still qualify for VAWA. Of course, you may be required to apply for forgiveness through the I-601 waiver. This means that you can overcome even any criminal inadmissibilities that you have as a result of the offense that you were convicted for. And here's an added benefit. If the offense was related or caused by the spouse or the relative who mistreated you, then you may not even need a waiver. An immigration officer may overlook that because of what happened. For example, if you were the victim of domestic violence, physical abuse, and you ended up fighting back, and then you turned out to be the one arrested as a result of you fighting back in self-defense, this can result in you not having to apply for a waiver and the officer forgiving the offense because of the nature of how it happened and because it's related to the domestic violence, with you being the victim. Here's something you should never do when you're applying for VAWA. Do not get remarried, and don't get married if you are even the son or daughter of a U.S. citizen or resident who mistreated you. Getting married disqualifies you from getting the relief of VAWA. That means even while you're going through the application process, you should remain unmarried if you're applying as a son or daughter of a U.S. citizen or resident, or if you are applying as married or even divorced from your U.S. citizen or resident spouse, you need to remain that way. And until you're approved, that's when you can consider remarriage. But for now, you must not take any action to get remarried or married throughout the VAWA process. Many people don't understand the kinds of benefits that VAWA brings. While you're applying for VAWA, in most instances, you are able to apply for your green card at the same time through the adjustment of status process. That means that you can apply for your work permit and your travel document at the same time that you're applying for the green card. And while you're going through the process, that's when they give you the work permit, they give you your travel document, and they give you your social security number to go with it so that you can find stability and independence as you go through this VAWA process. This work permit, this travel document, the social security number tends to last right up until you are approved for the VAWA. At that point, when you're approved for VAWA, you have official protection and they're going to issue a new work permit for you under VAWA while you apply for your green card. While you're applying for the green card through the VAWA process, as an immigrant applying through VAWA, you do not have to have a sponsor to show that they make enough income to support you. You are waived from this process of supplying the affidavit of support. When we're applying for our clients to get the green card through VAWA, we submit what's called an I-864W form, and that's the form that states why our client is waived from this process of supplying proof of income that they will be supported financially. Getting public benefits such as food stamps, Medicaid, does not affect a VAWA application process. Usually, in the immigration process, the immigration officer looks to whether an immigrant is called a public charge. A public charge means that they will likely be primarily dependent on public benefits like food stamps, like Medicaid, like cash assistance, like long-term care. In this case, this is not a part of the process for VAWA. An immigration officer is not going to hold you getting public benefits against you. As a matter of fact, during the VAWA process, you're issued what's called a prima facie determination letter. And that letter often allows VAWA applicants to be able to get much needed public benefits, especially if they're in a state of instability as they adjust and move into an independent state from an abusive situation. Working without a permit is going to get you denied for VAWA. Wrong. During the VAWA process, they do not hold working without a permit against you. You should always be honest in the application process and disclose to the immigration officers truthfully all your places of employment, because telling the truth is going to be more important than any kind of consequence that comes with working without a permit. There are no consequences in this case. VAWA is only for women. Not true. VAWA is for all genders. Stepchildren under immigration law are considered as a child whose parent married the U.S. citizen or resident before the child turned 18. So if you are in that situation where your parent married the U.S. citizen or resident before you turned 18 and you experience mistreatment by the U.S. citizen or resident step-parent, that means that you could very well qualify for VAWA relief as well. After approval of your VAWA petition based on mistreatment by a U.S. citizen spouse, you have a shorter path to gaining U.S. citizenship. That's correct. Once you're approved for VAWA and you get permanent residence through VAWA, you're able to apply for U.S. citizenship 3 years after approval of your VAWA green card. If you were in a common law marriage and that common law marriage is recognized in the state you were in, then you can qualify for VAWA relief. Common law marriage often means that you did not get married in a traditional way. Usually means that you may have lived together for a period of time to the point where you were seen to the public as a married couple. States differ on the way that they recognize common law marriages. As a matter of fact, fewer states recognize common law marriage. For example, here are some states that recognize common law marriages: Colorado, District of Columbia, Iowa, Kansas, and Montana. These are examples of states that recognize common law marriages. You should check your state to see if they recognize common law marriage, and if so, see how you can meet their requirements for the common law marriage, because it can be a basis for you to apply for VAWA. I bet you didn't know some of these facts before watching this video. If this was helpful to you, make sure you like, subscribe. This is how we're gonna get this information out to people so that they understand how they can be empowered in the immigration process. Until next time, take care.